Well, now, where do we go from here, Mr. Gill?
My Lord, very briefly, give just 3 references to House of Lords authorities in order to support the points that I've been making, that normal interests of immigration control, in a general sense, don't override rights to family life, certainly not the rights of children, and that one needs a rather more structured approach. Those 3 authorities are these. The case of Betts, which is at volume 1, tab 20, at paragraph 43, if I just give the references. Chikwamba, tab 21, at paragraph 44.
What paragraph of Betts?
Paragraph 43. It's
43 of Betts.
Yes, it's your Lordship's judgment speech. Then E.B. Kosovo, which is at tab 22, paragraph 12. Now,
12.
Paragraph 12. E.B. Kosovo, tab 22, paragraph 12. Now, these authorities are likely to be well known to the court. So can I take it simply in this way, for these purposes, that all 3 of these authorities begin to look at how Article 8 is to be applied in family cases, and all of them essentially say that it is going to be a rare case in which you enforce immigration control in circumstances where the family interests involved require otherwise. So if there is going to be separation between husband and wife or between parent and child, it's going to be a rare case where the interests, those interests can be overridden. Normal immigration control certainly doesn't come into it. It's got to be something like, we say, in line with our submissions in the other cases, something like serious criminality. So, a case like Chikwamba, where Lord Brown basically indicated that if you, there's no point requiring someone to go abroad and go through proper immigration control channels to make an application to come back into the country through the proper way, when Article 8 interests require otherwise.
Lord Brown uses the phrase comparatively rare.
Comparatively rare.
And E.B. is that Lord Bingham?
Paragraph 12 is Lord Bingham, and that's also saying rare. And Betts talks about the need at paragraph 43 to have regard to the interests of all the family members. And here we are beginning to unpack that and take that further by saying, yes, that's right, but the interests of the children require a particular consideration. That was all I was going to say on those authorities.
Well, you reminded us of paragraph 12 in E.B., and it is worth noting that Lord Bingham did say that the search for a hard-edged or bright-line rule to be applied to the generality of cases was incompatible with the difficult evaluative exercise. So the message he's conveying there is that one has to look very carefully at each case and make a careful and informed evaluation, which I think is in line with what you've been submitting so far. But then we have in this case the additional factor of citizenship, which wasn't in that case.
Well, yes, that's right. Well, children and citizenship. Because I think E.B. Kosovo, none of the children were, none of the people involved were citizens at any rate. That's right. I think there were children. There was a child, but not a British citizen child.
Right.
I think the daughter in Chikwamba probably was.
Yes, you may be right.
I'm not 100% sure.
Yes.
Well, I'm
Yes.
not, I don't,
No, it's not.
not
It
clear.
might not
There
be,
were
no.
both Zimbabwean nationals. One of them had been granted asylum.
Yes.
But I mean, certainly it wasn't a dimension to the case that I
No.
think any of us were alerted to, or
That's quite right.
Well, that is certainly true. So it's that factor that really adds extra weight in this case, and we would welcome your assistance on that point.
Yes, that, if I can move to that. Well, Lords, the submissions on this are summarised in paragraph 30 of our printed case. And you'll see that in paragraph 30, we say that this is a factor which has a very special significance, which can be decisive in some contexts, such as those that arise in this case. In fact, there are only going to be rare cases in which it will not be decisive in our favour. And then at 30C, we refer to the constructive removal point. And we say that that, in reality, in substance, amounts to forcing British citizens to go into exile, which has never been a penalty under the common law, even save in very, very extreme circumstances. We draw attention to certain circumstances in which deprivation of citizenship may occur, and I'll give references to that in a moment. And then we say in E, it's also unlawful and cannot survive in a lawfully conducted balancing exercise under Article 8.2, because it gives rise to anomalous results, especially in comparison to EU nationals, because it violates the principle of equality. That's essentially the Chen point, but those points are further amplified at paragraphs 86 to 88. And particularly at paragraph 87. Chen is separately dealt with, but I'll deal with that in a moment. If you just cast an eye over 86 to 88.
Yes.
Well, I mean, this is this point about equality, which, as you know, the respondent says none of this was argued below, and it's really late to start taking it here.
Yes, but in the application for permission, it was very clearly raised that this was going to give rise to discriminatory treatment, not least because the passages that were cited from Baroness Hale's lecture drew attention to this very point, and they were cited in the application for permission itself. It's got to be relevant to Article 8, and the first issue is couched in terms of Article 8. The paragraph 87 point is very much flagged precisely in Baroness Hale's lecture that was cited in the relevant parts on discrimination were underlined in the application for permission. But let me just try to deal with this reasonably speedily, I hope. My lords, if I can just invite the court to look at paragraph 31 of the printed case. Without taking time in going through the materials, you'll see that at paragraph 32, we've said that even in relation to foreign children, the approach that is set out in General Comment number 6 is adopted. And we say in 33 that cases like Maslov demonstrate, even in relation to such children, the need to take into account the solidity of ties, and the passages from Maslov are there set out, which we've already looked at. At paragraph 34, we say that even still looking at such children, the Secretary of State's own 7-year child policy, which is set out and referred to at footnote 3 of our printed case, itself provided a presumption against removal of children who'd been here for 7 years and their parents. But we say the important question, however, is how do you take that further in the case of British citizens? That's para 35. The starting point really is the Immigration Act 71, and this is set out in our paragraph 36 of the printed case. All such citizens, and they're all to be treated equally. Citizenship is a unitary concept, as is set out elsewhere in our printed case. All such citizens are free to come and go without let or hindrance. Now, there has in more recent times been slight qualification to the right of abode and the possession of citizenship. And at paragraph 39 of our printed case, we've said that some amendments have been made to enable deprivation of those rights, but the Secretary of State's policies limit those to those situations where the public interest is engaged on grounds of involvement in terrorism, espionage, serious organized crime, matters of that sort. I'm not sure that document's ended up in the bundle, but if not, we can get that for you. But I don't think there'll be any dispute about this, that those provisions are really geared to the sort of behaviors that are set out in paragraph 39. We've also set out in paragraph 41 that British nationality law, unlike US law and unlike the Irish law as it was at the time of the case of Chen and previously, British nationality law doesn't rely in the modern era on jus soli in order to give citizenship rights. It's a far narrower category of persons, so you can't just come here, give birth and acquire British nationality just by virtue of the fact of having been born on British soil, as you used to be able to do. If descendancy from British citizens is another matter.
Is the Irish position regulated by the Constitution?
Yes, I think that there was, however, a change after the case of Chen to modify the Constitution in order to get around the particular problem. So I'll explain that in a moment. Yeah. At tab 28, I'm not going to turn this up because we've set out such great passages in our printed case at paragraph 42 from it, is the case of M. And essentially, this was the first case in which the courts began to consider, well, what is the particular role to be placed by British citizenship, to be placed on British citizenship? And the Lord Justice Buxton said, if I can just take it for present purposes for speed, just from paragraph 44 of the printed case, which sets out his paragraph 23. He cites section 1 of the Act. He refers to that as a proud statement. And then in paragraph 27, having referred to the case of Lobe in paragraph 26, the Irish case in 2003, pre-Chen, he says, if that authority can be applied in our case, then the status of the child as a British citizen becomes effectively irrelevant. I would wish to approach that proposition with caution. He refers to the approach of the courts in Ireland and the US. And he says, but that's not what we do. He says, a child in our case has, however, acquired citizenship not simply by birth, but by a deliberate parliamentary decision expressed in the British Nationality Act. Child is a British citizen because she was not only born here, but born to a parent falling into a carefully limited class. That careful conferment of citizenship is to be contrasted with the somewhat adventitious acquisition of a citizenship of the Irish Republic that troubled the court in Lobe's case. Second, there does not appear to be in the law of the Irish Republic or the US the strong and general statement of freedom to live in the UK that is to be found in Section 1. And he said that this issue needed further exploration, and he doubted Lobe's case. Now, these comments have not been further unpacked and developed, but in the context of the domestic Article 8 jurisprudence, which we have then set out from paragraphs 48 onwards, you begin to see references in the Court of Appeal's decision. For instance, in paragraph 48, we've referred to Lord Justice Sedley's decision in AB Jamaica, which is to be found, just for the cross-reference purposes, at Volume 1, Tab 31. But Para 20 is set out there. He said that it cannot be permissible to give less than detailed anxious consideration of the situation of a British citizen. This was an adult. So the issue is beginning to come to the fore, and we have then explained why it is that the previous cases have not actually rejected our arguments, but are in fact consistent with our arguments for the reasons set out in the ensuing submissions. And in particular, however, I want to look at the case of VW, which is at tab 33, volume 1 of the authorities bundle. The relevant parts are set out, but in the printed case. But the point that is made at the Lord Justice Sedley at volume 1, tab 31, basically draws together the previous 33, paragraph 41, draws together the previous...
And the child there was a citizen, I think I can see from paragraph 3.
Yes. And he says at paragraph 41, there'll be many cases where whatever the appellant says, it can safely be predicted that the child will go too if he is removed. But VW's is not such a case. The child is a UK citizen and has a father who is now settled and has a right of abode here. So tab 33, paragraph 41. Many mothers faced with such a dilemma, the sort of choice that the European Court in Sen at para 41 found shouldn't be imposed. Many mothers faced with such a dilemma would break the maternal bonds in the child's interests and leave her with her father. A B, if unable to bring his family here, may elect to remain without them and so leave them fatherless in Ethiopia. And then he says at the end of para 42, well, you have to assess this carefully, but here in my judgment it is the hardship of the dilemma itself which has to be recognized and evaluated at the end of para 42. And at 46 to 50, he looks at the particular circumstances of VW. And the point that I want to end up with is this, that in paragraph 50, says, in my judgment, despite the elements which are capable of telling against the Article 8 claim, the enforced breakup of this family, which are capable of telling against the Article 8 claim, the enforced breakup of this family, the more so, not the less, if the breakup is to be only temporary. is not justified by the legitimate demands of immigration control. The appellant is a found asylum seeker, but no more. Her partner has no job at present, but he is her child's father and joint carer, and this country is his home. Above all, consideration is owed to the child who is a British citizen and who, whatever was to follow from his mother's removal, would be the principal sufferer. In the end, there is only one right answer. So whilst the language may not be the language of the 89 Convention and the way in which I've been putting it earlier, it is exactly the same approach in essence, because the words above all make it quite clear that the weight to be placed upon the fact of the possession of British citizenship by the child is very significant. And the other submissions, which are then going back to the printed case, set out at, from paragraphs 57 to 59, I'll take as 59 to 60, I'll take as read. I also simply draw to the court's attention the points that are set out from paragraphs 61 through to 71. These are all arguments which recognize the importance of residence, indeed in Slivenko, in a foreign child's case, long-term residence in the host state, but also, more importantly, from paragraph 67, the importance of the child's right to development as a citizen. There's a Council of Europe document referred to in paragraph 68, which is the cross-reference to that, is at volume 3, tab 68. So paragraph 68 of the printed case, cross-references is to volume 3, tab 68. But I don't take time to deal with and set these points out because they are there in writing. More importantly, having already referred to the importance of Article 24 of the Charter, which is then set out in paragraph 76 of our printed case. More importantly, we come to, at paragraph 80 of our printed case, the case of Chen. And you'll see the summary of Chen that is there.
Should we look at the report?
Yes. Now, Chen is tab 59, volume 3. Now, this was a case in which C, Chinese nationality, entered the UK from China, 6 months pregnant, deliberately went to Belfast in Northern Ireland, where a daughter was born. And because of the Irish law at the time, any person born on the island of Ireland could have Irish nationality. And she therefore argued that that was sufficient, even though there had been no movement across EU states for the child, that was sufficient to engage EC law. The state said, well, this is a complete abuse. They are openly saying they did this deliberately. And the opinion of the Advocate General, General Tizano, is important because it sets out in some detail the approach to child rights that is really the ECJ's approach. And At paragraph 32 on page 331, the Advocate General says that according to settled community case law, the fact of possessing the nationality of a member state other than the one in which a person resides is sufficient to render community law applicable. He, at paragraph 33, basically says that the link exists regardless of whether there's been exercise of freedom of movement. And the situation is therefore, although it looks purely internal, isn't really purely internal. He notes at paragraph 38 that under international law it is for each member state having due regard to community law to lay down the conditions for the acquisition and loss of nationality. But implicit in that is that once you have the nationality, it's got to be respected. And he then begins at 41 to look at, can a minor be vested with rights of movement and residence, and goes through an analysis of the relevant considerations. He says at paragraph 52, having regard to the points I clarified earlier, there is no reason to deprive a minor of a right conferred in general terms, the right of residence, on all community provisions by a fundamental provision of community law, such as Article 18. So the mere possession of European Union citizenship, purely by virtue of the accident of having been born on the island of Ireland, the pure possession of European Union citizenship was something which gave the child a right of residence, and that right of residence had to be made effective. If I skip over to paragraph 75, he recognizes that similarly in case of bombast in the past, child's rights to be present in order to claim education rights was supported, even though it may require the presence of the parents as well, who would otherwise not be entitled to remain. And then says at paragraph 90, the existence of a derivative right of residence, talks about the existence of a derivative right of residence for the parent derived from the right of citizenship and residence of the child.
Did you say paragraph 90?
Paragraph 90 of page 338.
Yes. Yes, I see. Yes.
And he basically, without reading those paragraphs out, it's 90 to 96. And in particular, paragraph 94, he cross-refers directly to Article 8 of the European Convention. These are family protection rights, the child rights coupled with citizenship rights that are in play here. He refers from paragraphs 97 to 106 to the discrimination that would arise if that child, in that case, wasn't allowed to have her legal entrant parents present in order to make the right effective, and concludes that discrimination would arise with other children. Paragraph 108, he talks about the argument of abuse, but says, well, once the state has itself taken, by paraphrase, it comes to this, once the state has itself taken the decision to give citizenship in a certain way, there's no room for the abuse argument. The court then says at the penultimate page of this tab, at paragraphs 42 to 47, what its conclusions is. And they look at the right of residence of a person in Mrs. Chen's position. And they say, and this is the crux of it in paragraph 45, on the other hand, a refusal to allow the parent, whether a national of a member state or a national of a non-member country, who is the carer of a child to whom Article 18, right of residence, and Directive 9364, granted right of residence, to reside with that child in the host member state, would deprive the child's right of residence of any useful effect. It's clear that enjoyment by a young child of a right of residence necessarily implies that the child is entitled to be accompanied by the person who is, or her, primary carer, and accordingly that the carer must be in a position to reside with the child in the host member state for the duration of such residence. For that reason alone, without looking at anything else, without even looking at discrimination, which I think was the point that my Lord Carr made earlier this morning to me, that was enough to give rise to the need to allow a mother to remain. Now, that approach, which is completely directed towards making citizenship rights of European Union citizen children effective, is an approach which we say should also apply here. It would be utterly pointless if it didn't, because after all, the family in this case, assuming mother was still to be expelled to Tanzania, the family in this case could, for a period of time, engage community law simply by moving abroad and coming back. What on earth is the point in the present case of bringing about a situation where the family in the present case say, well, we could actually invoke EC rights as well, simply by moving to another state and then coming back. But more importantly than that, that's not my primary argument. My primary argument essentially is this, that once you decide that you're going to give the children in the present case British citizenship by a carefully delineated parliamentary statutory provision, which is then exercised by the Secretary of State. Once you get to that point, and you've given people citizenship, you can't take away from them the consequences and the rights that come within that citizenship, even in substance.
Now, is that putting the point too high? Because at the very beginning of today's discussion, I think you accepted that the argument is that it's not a trump card, that this decision comes rather close to saying it is.
Yes.
But you're saying, well, you refer to Chen as an example of an approach, but you're not using that, are you, to say that you cannot move a child abroad in exceptional circumstances?
My Lord, I would be prepared to accept that given the fact that there are in some circumstances, there is the possibility in some circumstances of a deprivation of the right of abode or a deprivation of citizenship, statutory provisions to that effect. Given that that exists, it may be that in a very, very extreme case, that the family members, the British national children of a foreign national, may have to move abroad if that foreign national has committed some pretty significant crimes. That would have to be something like threat to the nation, something like that. Something extremely serious. So this category of a child is in a even more protected position than the category of foreign children who are long-term residents in the UK, the Maslow type children who are not British nationals but are long-term settled here. We know in those circumstances, it's still going to be very rare circumstances in which they will be forced abroad. But this last point that I've made, that there might possibly be some circumstances in which British national children might be forced abroad is simply because the statutory regime contemplates deprivation, but this is something that may separately have to be looked at on some other occasion when a case arises, because one of the things we've said is that we do not make any concessions on the validity of those provisions of the legislation which allow for the deprivation of citizenship. We've said that in our printed case. We make no concessions on that. And I know that in Mr. Hamza's case, the deprivation of British citizenship is a matter which has been troubling the Special Immigration Appeals Commission, which has in fact ruled in his favour very recently. But even that would be a very extreme case. And even there, the question would have to be confronted. Could you, in those circumstances, still visit the sins of the parents upon the children? Or might there be circumstances in which the children could say, well, even if theoretically it is possible to force us out in some situations, in particular facts of a particular case, it's not appropriate to visit the sins of the parents upon us. That would have to be looked at in an individual case when that case arose, but that's likely to be so extreme that a final decision on that last point as to whether it's decisive or not can be left to another day. But for my purposes, for the vast, overwhelming majority of cases, making the concession that I've done is more than sufficient. The question arises, what does one do in relation to the sort of scenario that Lord Brown put to me? Well, I gave the answer to that earlier, and Chen, we say, supports us on that. And
there's a bit of that in this case, isn't there? The suggestion, which one saw in the tribunal's judgment, that it was irresponsible to have children when her immigration status was in doubt. You would say, well, that's a totally irrelevant factor.
That's totally irrelevant factors from the perspective of the child. The children have come into this world. They are human beings who are entitled to respect for their rights. And that sort of factor is, although we're not engaging with the facts, is precisely why one sometimes needs to look at the facts to give adequate guidance, is that sort of factor is utterly irrelevant. Paragraphs 86 to 87 of our printed case, in particular, paragraph 86 essentially says, well, if you don't give an enhanced status and a special position to the best interests of the child, what you will end up doing is in effect discriminating against that child in the protection of that child's rights under the CRC 89, and indeed under the ICCPR, as compared to the protection given to adults. Because you're failing when comparing children to adults, you're failing to recognize that children have a special position, that their rights go that much further. If you fail to look at the issue in that sort of way, what you will end up doing is indulging in discrimination on the grounds, essentially, of age. And whether that could be justified or not is, for the purposes of this submission in 86, is not the point. The point really is, you've got to make sure the decision-making is done in a structured way. And again, the point at paragraph 87, it's essentially the point that Baroness Hale was making in the lecture, from which we've quoted at paragraph 89 of the printed case. And you'll see at paragraph 90 of the printed case, the bits that are highlighted in the middle of first in paragraph 90, Article 2.1 demands that states respect and secure the rights set forth in the Convention to each child within their jurisdiction without discrimination of any kind. And failure to adopt the approach that we call for gives rise to discrimination, although which is unjustified. And the final point in paragraph 88 is that if the Secretary of State is going to adopt the very, very general, vague approach that there is, that you throw everything into the scales and just look at it in a balance with no particular structured approach. Now, that doesn't, we say, sit well with the, or satisfy equality duties, well-known equality duties, for example, under the Section 71 of the Race Relations Act. And this is the point made in paragraph 93 of the printed case. As operated by the Secretary of State, the policy means no consideration has been given to whether to carry out any race equality impact assessments. Certainly no impact assessment has been carried out as to the impact on children and children of any particular racial group. The effect really is that parents are told, well, you choose, you decide what you're going to do, and the discriminatory impact of that approach on children is simply not addressed. I'm not, in this context, saying anything about whether it could be justified or not. I've said in some extreme cases there may possibly be a basis for justifying. But what we're concerned to do is to get some guidance which sets out the approach that decision makers should adopt. And that, I think, covers the submissions in relation to British citizenship. I want to draw attention to, partly because of something Lord Brown raised, to a South African decision which I would commend to your lordships and your lady. It's in the loose bundle at tab 92, the second of the two tabs.
Yes.
This is a case in which Justice Sachs gave a judgment in which the majority concurred on the proper application of the paramountcy or the best interest principle in South Africa. What they've done essentially is to do a bit like Article 24, bring in the principle of best interests down into domestic law. And what they've done is enacted a Section 28 of the Constitution, I think it was. And if I can just, the question that arose in this case is what to do with a child of a mother who's committed criminality. You have to lock up the mother, but what about the child's interests? And perhaps the holding, and I'll just give reference to paragraph numbers in a moment, perhaps if the court could just cast an eye over holding number 1 on page 2. in the judgment itself the significance of enacting Section 28.2 and how it then begins to drive a different approach. That is considered at paragraph 12 onwards. And for instance, at paragraph 16, it says, Section 28 must be seen as responding in an expansive way to our international obligations as a state party to the Convention on the Rights of the Child. And we say, well, so also we have the lifting of the reservations, we have Article 24 of the Charter, we have Section 55. Paragraph 17, he says that therefore regard has to be paid to the import of the principles of the CRC.
I mean, do you happen to know, Mr. Go, whether these considerations and these international instruments inform sentencing in the criminal jurisdiction? I've no idea. It's years since I've been near it. I mean, do people go to court and say, well, there it is, this woman is whatever, a drugs mule, but she has children, and et cetera, et cetera, et cetera. I mean,
My Lord, okay. My Lord, I'm sure people make submissions to the effect that the interest of the child should be considered, but I'm not sure that there is any structured approach. I'm not aware of any guidance, say, instance, from the Judicial Studies Board or other sentencing manuals as to the approach to be taken. And what we're hoping comes out of this case is which is what I have said at the start about guidance, is that something is done in order to try to prompt at least a look at the sort of guidance that should be coming out to judiciary faced with these sort of issues.
Well, some of the factors, and I'm simply glancing at paragraph 28 onwards, ring a faint bell with me as the kind of things that were mentioned in pleas in mitigation before the Human Rights Act came in. It was material which a sentencing judge would listen to and might take into account. But what this judgment seems to be doing is putting, as you've said before, a structure on the exercise.
And
which,
that's what we
I suspect is absent at the moment, but I may be wrong.
Yeah. That's what we commend, and that's what's necessary. He does say that the best interests are not absolute; they can be overridden. Looks at competing interests at paragraph 37, and he also looks at paragraph 42. That the children, however, are innocent of the crime, and then considers the amicus's submissions in that regard.
I mean, this case is everything about children, but has it got anything especially about nationality or not?
Not about nationality.
No, okay, that's all I asked. Yeah. Thank you. I mean, I appreciate you say nationality is a fortiori, but yeah. I just wondered if it was. Yep.
Well, Lord, I've gone on too long, and those, I think, are the submissions on issue 3. We simply say it's taken up. That's effectively now conceded. The what should happen on the facts of the case.
Yes.
But we say it's taken the Secretary of State up till now to decide that the AIT and the Court of Appeal were wrong, and the appellant is entitled to a vindication of her Article 8 rights, and to know that it is respect for those rights and for the rights of the children, which should have given her the certainty of success before the AIT. And therefore, the appeal should be allowed with costs. And as regards the point about looking at the circumstances in which academic appeals may now be considered for the reasons that we have set out in our printed case, which cross-refer to, I'll just give you the paragraph number. Should you wish to comment on this, then we respectfully suggest that the court should. We have said at paragraph 117 that the test in Salem needs some modification for the reasons that are set out in the letter written to the court, particularly at paragraph 20 of that letter, which I won't take time to elaborate on. Those are the submissions.
Yes. Thank you very much, Mr. Singh. Mr. Hawkin, would you like to add anything?
Absolutely not, my lord. I think my leader said everything that needs to be said.
Very well, thank you very much indeed. Now, Miss Dodson, I think you followed, didn't you?
My lords, my lady, I adopt on behalf of the interveners the submissions made by my learned friend Mr. Gill, and I have only two short submissions by way of addition to what he has said. The first relates to the area of the voice of the child.
Yes.
And the starting point is, of course, that the United Nations Convention on the Rights of the Child guarantees, by virtue of Article 12, the right to express views and the opportunity to be heard. The text of Article 12 is set out at tab 43. Reference should also be made to General Comment number 12, which will be found at tab 63 in the bundle. I should point out respectfully to the court, in the context of this submission, that the interveners are a girl, T, who is nearly 12 and a half, and a boy, Javed, who is nearly 9 and a half. The submission is that it is apparent, if one examines the various determinations in relation to this case, that no attempt has been made to ascertain the views of T and J. This notwithstanding that the appellant's first application for indefinite leave was made as long ago as October 2000.
At that time, October 2000, the boy had not yet been born. I think I'm right in saying, and the daughter would be aged about 2.
The boy was
born in 2001.
In 2001, that's right, and the girl in 1998.
Yes.
Yes. So, of course, the point arises most notably when the children are older than they were at that point.
Well, the clock moves on, I would have thought, in the history to about August 2007.
Yes.
When the fresh representations were made and accepted as a fresh claim. So there you are, you can start again with an appeal.
Yes.
And we follow it through. But by 2007, I can see the force of what you're submitting, that you're getting to an age when the children might be expected to have views. And of course, as time moves on through the tribunal system, that gathers pace more and more.
Exactly so. My lords, the relevant occasions on which a determination took place in relation to the appellant's claim are the 8th of January 2008, which was the date of the Secretary of State's decision. There followed a determination by Immigration Judge Rowlands, the 4th of March 2008, declaration of the determination of the IAIT of the 5th of August 2008, and the judgment of the Court of Appeal on the 26th of March 2009. It is to be noted that giving judgment in the Court of Appeal in March 2009, Lord Justice Moses said, and this will be found in appendix to the appellant's case, page 10, paragraph 27, what was in my view all important was the effect on the children. But although he concentrated there on the effect on the children, no information was available to the court about the children's views, their wishes and feelings.
Doesn't one make an assumption?
Well, it may be that one does make an assumption, but it may be that one should not make an assumption, because although it appears that in this case the interests of the children and the interests of the appellant are consonant, they need not be. So I think Lady Hale remarked in the context of the case referred to by the respondent in the respondent's printed case.
Are there two ways of approaching Article 12? One is the actual, as it were, interviewing of the children by some responsible person, so that the children's views can be reported to the court. And the other is what you're doing just now, which is representation by an advocate on their behalf, so that not just the views of the children, but the arguments that can be put forward, arguments in law in favour of their position can be put forward as well. So I would suggest that built into Article 12 is both the advocacy side and also the obtaining of individual views. But that gives rise to questions as to exactly how this should all be done. It wouldn't be necessary, would it, in every case, for the children to be separately represented, would it?
Well, clearly not. But it might well be necessary in every case to ascertain the views of children who were old enough to express views. And, of course, the decision, or the series of decisions which have been made in this case, have been and are as important to T and J as the outcome of care proceedings for children who are the subject of care proceedings. Those children, however, are parties to the proceedings, and they are represented in the proceedings, usually through a children's guardian, and public funding is available for them to be legally represented. It is the case that here the children's views would at this stage be carrying a considerable weight by virtue of their ages now and their ages at the time of the relevant determinations. The difficulty perhaps arises from the fact that there are no established procedures for ascertaining the views of the children in proceedings such as these, nor are there procedures available for them to be represented other than by virtue of the powers which were exercised to ensure they were represented today. it may be helpful if I inform the court of what has been done by those instructing Mr. Nicholson and me with regard to obtaining the children's views and with regard to obtaining representation for them.
Yes.
They consulted CAFCAS in the first instance. And in fact, there was an exchange of correspondence, the upshot of which was that CAFCAS could not assist either in terms of ascertaining the views of the children nor in terms of arranging representation.
Did they give a reason for that?
That these were not family proceedings. If that were not an obstacle, it may well be that resources would be an obstacle in any event. An informal conversation took place with the head of the legal section of NIAS, the National Youth Advisory Service, and it was agreed that in the particular circumstances of the case, there was no role for NIAS as representatives of the children.
No room, sir.
No role,
Row, thank you.
because the solicitors acting for the mother could, in the circumstances, also act for the children. However, they did indicate that in an appropriate case, assistance might be available in ascertaining the views of the children, but it wasn't thought right to canvass the children's views in the particular circumstances of the present case, because it wasn't thought right to tax them with what is a hypothetical question at this stage. But in conclusion of this submission, I would invite the court to give consideration to the procedures for enabling children to express their views and enabling them to be represented if it is thought that the present state of affairs is not a satisfactory one.
You mind me pressing you just a little bit more on this, because as you rightly pointed out, there were 4 determinations
Yes.
in this case. At which point does this come in? I mean, let's take the initial determination by the Secretary of State. I'm not certain whether your submission would be that he or she should arrange for views to be obtained before the determination is made, or whether one brings it in at the stage when it begins to become part of the appellate process.
Well, it would be my submission that it would be appropriate to canvass the children's views at the earlier stage,
Right,
as well as at
Yes.
later stages.
So they would in effect be on the table from the very beginning. Would that be right?
Yes.
And could be updated, no doubt, as they get older and
Well, quite
circumstances
so,
change.
yes.
But I mean, wouldn't mother be, I mean, because it's so obviously in a case such as this, and probably in the great majority of cases, in mother's interest to emphasise the impact on children if either they're left behind or forced to leave in order to accompany her. I mean, why wouldn't mother be expected, insofar as it's a good idea because of their age and all the rest of it, to question them, to fulfil that role?
Well, the interests of the mother and the interests of the children don't necessarily coincide.
Well, in the vast majority of cases, they're going to, aren't they? I mean, and certainly in any case like the present, they will. won't they? I mean,
It is interesting. You can find out things that you didn't know from children.
Exactly.
Yes.
I'm remembering the Zimbabwean case that we had, where we arranged for the children to be separately represented. This was an abduction case.
Yes.
And it became apparent that they had had very clear views. They did not want to be abducted from Zimbabwe. They didn't want to come here. But they'd made the best of it. They'd settled down, and they now were settled here, and they did not want to go back to Zimbabwe. And that was a different perspective on it from the one that the mother was putting forward.
Yes.
So you could never be entirely sure what the children are going to say.
And I think you get a case like this, where if you read the tribunal's decision, they're extremely doubtful about the credibility of the mother.
Well, they
and
are.
That's a shadow that's right over this case. And any views that she might have communicated to the members of the tribunal about the children's feelings and views and so on would be subject to that disadvantage. Whereas if you go direct to them, then you've got them standing on their own 2 feet, explaining their own position. So speaking for myself, I can see the value of an independent approach to the children, which doesn't channel itself through either parent and is subject to the reservations that might attach to the parent's own evidence.
Yes. It is perhaps worth adding that in this case there was a great deal of doubt about the credibility of the father,
Yes,
too. I
indeed.
appreciate, of course, that he was not a party to these proceedings.
So it didn't matter which parent it went through, there was going to be a problem about credibility.
Potentially,
in
yes.
this case, not necessarily every case, but in this case.
Yes.
Presumably you would submit that all of the courts, and indeed the tribunal dealing with these children's case, should be astute to their obligations under the Human Rights Act to ensure that the voice of the children is heard, if that is deemed necessary.
Yes.
I mean, in Northern Ireland, for instance, perhaps we take a rather less, to borrow Mr. Gill's phrase, structured approach to this. In a case such as the present, if a judge felt that the children's voice should be heard, he would simply engage the official solicitor to speak to the children and make representations on their behalf. I take it there's no analogous procedure here?
I think the official solicitor would now restrict his role so that it did not include the carrying out of duties such as that.
Why, I wonder?
Well, I think that the office of the official solicitor and the functions of the official solicitor has changed considerably with the advent of CAFCAS. And for the most part,
But if Kafkas doesn't feel able to do it because these aren't, strictly speaking, family proceedings, it seems unfortunate that the official solicitor should restrict his role, but perhaps that's not a matter for you.
well, I make the submission that I make on the basis that the official solicitor's role does not include ascertaining the views of children or representing children at this point.
Have you ascertained whether that's his attitude? I mean, one could ask him, just as you're inviting us to ask the children. If it happens in Northern Ireland, it may be that Lord Kerr is absolutely right, that there's no reason why it shouldn't happen here.
In a way, my recollection is that the role of the official solicitor is to represent people who are under a disability in relation to litigation generally. But that role in respect of wardship and other family proceedings about the upbringing of a child has been taken over by CAFCAS.
Yes.
But it doesn't follow that the general role has been taken away. The general role of representing people, including children who are subject to a disability, doesn't follow that that's been taken away, just because part of it's been carved out, or the major part of it's been carved out and given to CAFCAS.
Well,
We don't know the answer to that, do we?
I mean, we're at a disadvantage in two respects. We're not legislators, obviously, and we don't hold the purse strings either. So maybe the furthest we can go is make recommendations that those who are in a position to know and actually bring things into effect should look at this. And if I've understood your position, you would say that the views of the children should be ascertained at the very beginning, before the decision process is put in train.
yes.
As far as advocacy is concerned, that's a different issue, and it may be that one has to say that in the general run of cases it's not really necessary, but there may be some where it is, and
Yes.
this perhaps is an example of where it would have been helpful to have had somebody representing their interests, so that it was made quite clear that whatever sins and various defects there were relating to the parents, the children were to be regarded as individuals in their own right.
Yes.
Whereas that might have been necessary here. I mean, if we say it in the way that we're invited to, I mean, it may not be necessary in future. Because you can't assume that courts are going to continue. I mean, if this is the way it turns out at the end of argument, if we regard courts hitherto as having paid lamentably insufficient attention, etc., and make it plain, well, then in future, no doubt, because otherwise there are going to be immense resource implications. Well, I mean, I don't know about that. I haven't the faintest idea how many of these cases there are.
It could be. I mean, Lord Brown, after following Lord Brown's point, I mean, with great respect to your presence here, is immensely helpful because of the issue of law we have to deal with in this case. But it's if we resolve it in favour of Mr. Gill and yourself, then that should settle the position. And it would only be at an appellate level, if there are issues of principle like this that come up where a separate voice is needed, that the court would regard it as at least necessary at the extreme case, but helpful in others.
Yes.
Well, anyway, thank you very much for your assistance on that issue. Is there anything more you think you can helpfully tell us about that before we go further?
On that issue, I think I need say no more. Perhaps, with this exception, that whatever advice or guidance might be given, it would, I think, have to encompass the fact that CAFCAS's resources are extremely overstretched. So that is not an obvious way of redressing the lack of any effective mechanism for conveying the children's views. May I turn now to my second submission, which concerns an aspect of the best interests of the child. If your lordships and your ladyships turn to, I think it is page 6 of our written case. You will find paragraph 11 a quite lengthy quotation from Lord Justice Ward's judgment in Re Z. But before I invite your attention to that, may I invite your attention to paragraph 10, which sets out section 1 of the 1989 Children Act. I am afraid that this did not reach the bundles of authorities, but it is there set out.
And this is all we need. Really,
And I
for your
think
point.
it is probably all your lordships and your ladyship needs. And I draw your attention to this on the basis that I am going to invite you to consider whether Section 1 of the Children Act 1989 applies to decisions or determinations such as those which are the subject of the instant appeal.
Well, if they are, would you have needed section 55?
Possibly not.
Well, this is a very great deal stronger than Section 55.
But it is stronger. It is stronger in this respect that it sets out that the child's welfare shall be the court's paramount consideration in cases where the section applies.
I mean, your Plúd Wireless Killer One, Mr. Mandic Gill doesn't go as far as this, does he?
Well, he doesn't go as far as this in one sense. Perhaps I can reply to what is said about Section 55. That section does not refer to the child's welfare being the paramount consideration, nor indeed does it refer to the primary or a primary consideration.
You recall we were referred in the tab, Bundle 1, tab 10, to the policy document.
Yes.
And I think it was in that document that we saw the difference that was drawn, or distinction between child welfare matters, which is
Yes.
Section 1, and the matters of questions of how public bodies deal with things such as immigration and so on, which we're dealing with here.
Yes.
The message I thought was that in child matters, the word "the" was given very, very heavy weight indeed, whereas in the others, it was, although a primary consideration, there was a little greater latitude for other factors to come in. Is that a fair assessment? And are you saying the policy document was wrong, and the same approach should be taken all the way through, whether it's a child welfare matter in that strict sense, or whether it's relating to matters of administration?
No, I'm not saying that. I'm raising for the court's consideration that there is an issue as to whether Section 1 of the Children Act applies.
It can't be right. I mean, without seeing the whole of the Children Act, it's a little difficult to judge, but I would think it was amazing if it was dealing with immigration, and the existence of Section 55 tends to confirm that.
And also, of course, we're not normally talking about decisions of a court.
No. But one is talking about tribunal decisions and, in this case, of course, a decision of the Court of Appeal. Perhaps I can attempt to set out the issue perhaps more clearly than I have so far.
What, again, arguing that Section 1 applies?
That consideration should be given as to whether it does, at any rate. Because if it does, of course, welfare is the paramount consideration.
Well, what about my lady's point? Primarily, it would have to be directed at the Secretary of State, not at the court.
In fact, the duty that the Secretary of State has under Section 55 is remarkably like, as I recall it, and I'm sure you know it better than I do, Ms. Dodson, the duty of a local authority under Part 3 of the Children Act, which is to safeguard and promote the welfare of children.
Yes.
Which is what you might expect. Section 1 is aimed at what the court has to do, and the court is weighing competing claims as to what's the way forward in the bringing up of the child.
Yes.
Wouldn't have much application to bringing in the child from Turkey in Sen's case, would it? I think I'll see myself, I think when you come on paragraph 13 of your printed argument, it's more helpful.
Yeah.
Yes.
And section 11 of the Children Act 2004, which you have a footnote,
Yes.
that applies not just, well, it applies to every person and everybody. To whom the section applies, and there's a list of bodies. Do they include the immigration authorities?
No, I believe they don't.
They didn't, because of the reservation. The purpose of section 55 is
Yes.
to bring them in.
Right.
Yes,
yes.
that
intended to achieve the same
quite
result.
right,
Yes,
yes.
thank you very much. Yes,
Yes.
exactly.
However, if I am right that the provision of section 1 may apply, it does have obvious consequences in the sense that it imports the words paramount
You
consideration.
have made that point, and
Yes. And it is obviously in contradistinction to a consideration of the first importance. The argument against the applicability of section 1, of course, is that the decision is a decision in respect of the mother's removal, or a decision in respect of the Secretary of State's exercise of his powers, rather than a question relating to the upbringing of the children. However, I say again what I said in relation to representation of the children and of their views, that the outcome of this type of proceedings has a profound effect on the children's future lives. Not happily now in this case. The only other matter I think that I can assist with is the distinction between a primary consideration and the primary consideration. We deal with this at paragraph 20 of our printed case. The example which we have not included, but which may be helpful, is the example of a case in which rights conflict, namely the case involving Siamese twins whose interests are not identical and quite the reverse. In any event, the primary consideration or a primary consideration, in either case, welfare needs to be considered first. That's the starting point. And we would suggest that Article 8 raises a presumption that welfare will prevail unless the presumption is displaced, which may simply be an alternative formulation. Those are my submissions.
Thank you very much indeed. Mr. Nicholson?
My Lord, I don't wish to add anything further to it.
Yes, Miss Carsfrisk.
My Lords, there have been times in the course of the argument today when I've wondered how much, if anything, is left to argue about in this case.
We are looking for assistance. I think. Anything you
Yes.
can do to help us would be most
Yes, and I do believe that certain areas of dispute have crystallised.
Yes.
We can state our case in three very basic propositions. The first one is that Article 8 calls for a fact-sensitive, evaluative exercise, whereby each factor...
Sorry, if we've got it all in 3 sentences, I'd like to write them down.
I'm so sorry, my Lord.
Fact-sensitive what?
Fact-sensitive, evaluative approach in which all relevant factors are carefully weighed,
Carefully
weighed, and no one factor is predetermined to be decisive.
predetermined.
To be decisive or treated as a decisive, inevitably decisive factor.
That's really Lord Bingham in Kosovo, isn't it?
Indeed it is, my Lord.
Yes.
The second basic point is that we absolutely accept that the best interests of a child are a primary consideration, a consideration of first importance. Contrary to what Mr. Gill at times suggested today, it is not the Secretary of State's position that it is simply a factor to be thrown into the balance, just the same as any other factor. As I've said, it's primary, but it does not follow from that that we accept that it is paramount in the sense of inevitably trumping all other factors.
And that's not Mr. Gill's position either.
That's not Mr. Gill's position. As I understand his position and Miss Dodson's position now, they would say not paramount in all circumstances. There could be factors such as the need to protect the public from the risk of crime that could outweigh the best interests of the child. But they would, I think, deny that the general interest in immigration control is an interest that could outweigh the best interests of the child.
I think they stick to comment number 6.
They stick
We've
to...
looked up before.
Yes.
Non-rights-based arguments such as those relating to general migration control can't override best interest consideration. And that's the point at which you disagree, as I apprehend.
That is the point on which we disagree. Absolutely.
Well, we better get the third basic proposition.
That's right. Third basic one is the British citizenship of a relevant family member is a factor to weigh in the balance, but it is not inevitably decisive, and its weight will depend on all the circumstances.
you say of a relevant family member, but does the point acquire any greater weight if it's the British citizenship of a child?
If one looks at British citizenship as an independent factor, it doesn't, in our submission, actually acquire greater weight when it refers to a child. But it's right to say that this case, and I think the issues as defined, does of course focus specifically on children.
Well, must it be considered, in the case of a child, for what weight it may have as an independent factor?
It must be considered for what weight it may have as an independent factor, I agree. And it would have to be so considered in relation to a relevant adult, such as a spouse, who might be effectively required to move abroad if she wants to maintain family life with her husband.
But can it also not play a part in looking at the best interests of the child? I mean, if it's a valuable factor for a child, must it not inevitably sound on what is in the child's best interest?
It may indeed be part of that. Any benefit that would accrue to the child if the child stayed here might be said to go into the balance. That could be one of them, but of course we're being asked in this case to address it as an independent factor, but I agree, my lord.
Presumably you could get, depending on which other country was in play, a situation of dual citizenship.
Yes.
And then I suppose, we haven't been discussing that, but I suppose in that situation, British citizenship might well reduce in significance if the child actually had the relevant foreign citizenship as well.
Indeed it might.
Or was entitled to, possibly.
Indeed. And there are other factors, and we'll come on to this in greater detail, of course, but one of the difficulties we see with seeking to elevate citizenship into a very special factor is that one risks diverting attention then from other factors that may be just as important or more important, such as the length of time that a child has spent in this country, the general level of integration, all those sorts of factors that one sees in the cases. But the factor my Lord Vance just mentioned, yes, is something that would potentially come into it too, the possibility of dual citizenship.
I mean, presumably it was a factor in Chen. I mean, if Mrs. Chen had gone to Ireland today and the child would not have been an Irish citizen, then no doubt the result of the case would have been different.
Yes, indeed. And Chen, of course, is, we would say, a very special case in that it deals fairly and squarely with status and the consequences of EU citizenship, which of course is not what we're dealing with here, being fairly and squarely within the ambit of Article 8 and the balancing exercise that that requires.
Speaking myself, I would, however, find it helpful to interlock the two, because I mean, I'm not quite sure how they do interlock. I mean, would it have made any difference there if the child had been born here and because I know it wasn't so there, but because it had a settled British father, it was a UK citizen. I mean, would the European Court of Justice say, as in Chen, you know, mother has to stay too? I don't know. I haven't really sort of worked it out. I mean, was the fact that it was in Ireland? I mean, there wasn't any cross-border dimension to the case, as I understand it. Was there?
Well, I thought there was. I thought that created the cross-border thing. Although she wasn't, the child was not actually going. There was no question of moving to another member state.
No, exactly.
But the fact that it had acquired this status because of its right, its citizenship of another member state made the difference, as I understood it.
Yes, I think that is right, my lord.
It's got to be of another member state, is it? Not just of a member state, including our own. I mean, that's slightly.
I think you have to move in order to acquire the European right, don't you? From
That is my
member
basic
state of the
understanding.
Union to the other.
Yes.
Well, I
so there was
don't
a
think
double
Yeah.
whammy through going to Ireland. Firstly, you've got the local
Yes.
nationality, and secondly, you've got the benefit of the European principle.
I'm not sure about that.
Any child
We
born
need
in
to make
Northern
the
Ireland
case.
at that time had the
Yeah.
right to citizenship of the island of Ireland.
Yes.
That's obviously why they went there.
Oh,
They
yes,
went there
correct.
because they could get Irish citizenship.
That's right.
Ireland still using the jus soli, which of course they couldn't get simply by having the child in the United Kingdom.
Absolutely.
Yeah.
But all I'm saying is if you do manage to have a child in the UK which does have, for other reasons, British nationality, I'm not sure that Chen wouldn't apply. I just don't know.
I thought you, sorry, we're all talking across you, but I was thinking your point was that Chen is extremely interesting if you're dealing with movement within the European Union.
Yes.
But am I right that you say it doesn't have a wider significance in immigration control outside the EU?
Well, I would say that, but the particular point I was seeking to make here is that it's very specifically concerned with EU citizenship and status, that status, and what consequences flow from that. You have a right, and you look at the consequences that flow from that right, in this case for the primary carer, the mother. And the simple point I'm making is that that is very different from Article 8, which by its nature involves a balancing exercise where you're not concerned with the grant of citizenship status in the first place, but you are looking to protect the core value of family life. And you're then looking at the circumstances in which that may be interfered with, and interference will be justified. So, in that sense, I would caution against seeking to read across into Article 8 from Chen effectively a sort of absolute right for a primary carer and to stay in this country because a child here has British citizenship. Because, as I say, Chen's starting point was that the child has a right and that had certain consequences in EU law.
So it's an absolute right of freedom of movement, which goes with the status.
Yeah.
And there's no balancing one way or the other. It's just simply
exactly,
a
it's
right
looking
to
at
enjoy.
the consequences of that right that the child has. Now here, of course, the challenge is not that as a matter of British citizenship, certain consequences inevitably flow from that status. That is not the challenge. The challenge is specifically Article 8, which, of course, is concerned with family life and balancing, and where the starting point is always there is no right to enjoy family life in a particular country. Article 8 does not grant a right of entry or a right to remain for aliens. Those, of course, are well-known basic propositions, but they are important. And that is why we say you have to treat Chen with some caution and can't simply read across into this context.
Well, thank you. Those are the three propositions.
Yes. We have, so far as the first one is concerned, the idea of how fact-sensitive this all is. We have set out a number of cases in paragraph 7 to 11 of our printed case. I was going to invite you to go to just one of them, that is the EB Kosovo case. I think you were referred to briefly, but it's probably worth just looking at some of the passages. In particular, paragraphs 9 and 12. Tab 22, bundle 1. So paragraph 9 of the speech of Lord Bingham at page 182. Referring back to what the House had said in Rasgar, in seeking to give guidance to appellate immigration authorities, the House emphasised the importance of careful investigation of the relevant facts And he then cites a domestic decision and a further one, finishing the paragraph with a quotation, "Of course, all will turn on the facts of the individual case." And paragraph 12 is then the key paragraph. Thus, the appellate immigration authority must make its own judgment. That judgment will be strongly influenced by the particular facts and circumstances of the particular case, etc. And I could just invite the Lordships and Ladyship to read that whole paragraph, the particular emphasis being on the last sentence, "Search for a hard-edged or bright-line rule to be applied to the generality of cases is incompatible with the difficult evaluative exercise which Article 8 requires." Now, of course, one notes that Lord Bingham was able to give a certain amount of general guidance in the middle of paragraph 12 about certain relationships between spouses and parents and children. But nevertheless, the central message we would suggest is indeed that there's no substitute for looking very carefully at the individual facts of a case. And similarly, we would suggest, if one goes to my Lady Baroness Hale's speech at paragraph 32, page 190, at the second sentence, in particular, I agree that prolonged and inexcusable delay on the part of the decision-making authorities must, on occasion, be capable of reducing the weight which would normally be given to the need for firm, fair, and consistent immigration control in the proportionality exercise. That is a legitimate aim which will normally carry great weight in immigration cases. The heavy administrative burdens which such a system entails are well understood. But in Article 8 cases, one is always concerned with whether the correct balance between the legitimate aim and the means employed has been struck on the facts of the particular case. So the notion that factors may carry different weight depending on the particular case.
No, correct me if I'm wrong, but the issue which Lord Bingham is looking at paragraph 12,
Yeah.
is the relationship, the close and genuine bond between one spouse and another. So he doesn't seem to have in the forefront of his mind the problem we have in this case, which is the rights of the child.
Well, he's of course also looking at a genuine and subsisting relationship between parent and child.
Yeah.
That's the other factor he mentions. It's true, he doesn't specifically refer to the perspective of the child, but he clearly has that.
We didn't have a child in that case.
No, indeed. Yeah.
So one has to bear that in mind in looking at paragraph 12. That's the only point I'm suggesting.
Yes, one does have to bear that in mind, but nevertheless, the general tenor clearly is be fact sensitive. And I don't seek here to detract at all from what I've already accepted, which is that the best interests of a child are indeed in a special category. That is where, in a sense, you do depart from a wholly fact-sensitive approach in that you know from the outset that the best interests of a child will be a primary factor. So really our emphasis on the fact-sensitive nature of all this under Article 8 is really directed to the point about British citizenship. And we would suggest that the authorities show that the court should really be slow to single out any one factor out of the identified relevant criteria.
But I do have a
as
bit
carrying
of, I have a bit
particular
of a
weight.
problem with that, because you are not allowed to expel citizen children. You're not allowed to do it. And that's a given. That's a principle of international law. It's a principle of domestic law. You're not allowed to do it. And indeed, all the answers to parliamentary questions about how many children are, in effect, being exported are met with the response, we don't export citizen children, which means that you don't count how many there are. Perhaps you've started counting now, and no doubt those instructing you'll be able to help. So we don't know how many there are involved in this. So you have to start from that as a proposition and ask, to some extent at least, whether the effect of your decision on the primary carer is going to mean that these children are constructively deported. You've got to ask that question. That has to be.
My lady, I'm not suggesting you shouldn't ask the question. Of course you should ask the question where the children are likely to end up living. You have to ask that question in any event, of course, to look at their best interests. And of course you bear in mind, as I've said, that if they are British citizens, they have a right to be here and certain benefits flow from it. You do have that in mind, but ultimately our submission will be that given that we are concerned with protecting family life, the ultimate question is really whether family life can reasonably, sensibly be enjoyed elsewhere, bearing in mind, of course, very much so, the impact on the children and what they may lose if they go, say, with their mother abroad. But of course there is no question, I know your ladyship is aware of that, of forcibly deporting a person with British citizenship. That is done on a voluntary basis if that is ultimately considered the best solution.
It's done on a voluntary basis from the point of view of the parent.
Well, my lady, not necessarily from the point of view of the parent, in the sense that it may also be the point of view of the children. It all depends.
Do you mean to say the children are asked?
Well, my lady,
Any official actually asked?
I certainly hope and believe that their views are communicated in some way, my lady. And that is, of course, a topic that I will have to come back to, I know, in response to Miss Dodson's submissions.
If arrangements were made, there would be no obstacle to the children staying, of course.
No, indeed.
You've accepted that the welfare of the children isn't, as you put into the scales, as simply another factor. It has to be given a certain primacy of importance. If one moves to the question of nationality, given, as my lady has said, that one must not and one does not deport children or take decisions which will have that effect, again, is that a factor which is more important than simply another factor? Or is that just a factor that goes into the scales as one general factor?
My lord, it's the latter. We would say the fact that there are citizenship ties, if you like, with this country, and of course there could be other sorts of ties. One could envisage a child having indefinite leave to remain, different of course from citizenship, but nevertheless entitling the child to be here.
So it's just one factor.
It is a factor, and the weight of it will depend on the circumstances, of course. It may be that if the countervailing interests are less strong, i.e. the countervailing interests in removing the parent, the weight of that factor may be greater. But the point is simply that one cannot say that it will always be a particular...
No, I'm not inviting you to say that it always will be, but... Yeah. Do I gather you submit that it has no more intrinsic importance than any other factor?
Yes, no more intrinsic importance, but certainly relevant.
What one's talking about is the ranking of factors which go to make up the best interests of the child, and I think you accept that it is an interest of a child to grow up in the country of which it is, or he or she is, the citizen.
Well, I certainly accept that there are certain benefits that flow from that for the child, but if, for example, the child is very, very small and has not yet in any sense developed roots here...
But surely it's in the interests of a child to develop roots in the country to which it belongs.
This is one of the problems that there is in this area. the notion that a baby is a package that can be carted around the world wherever his or her parents are, and doesn't have an independent interest, as my Lord is, I think, putting to you, that if you have a nationality, you have an independent interest in growing up in the country of your nationality. Think what goes with that.
That I entirely accept that, and that's I put the emphasis on what goes with that, and I absolutely accept that, my lady. Yes, yes, there is an interest
My
there.
concern is,
Yes.
that people are thinking that a young child doesn't really have this interest, and I'm trying
very
to
much
suggest
hope
that a young
that-
child does have this.
I very
interest.
much hope that isn't so, and I say again, we absolutely accept that these are factors that go into the balance. They will be part of looking at the best interests of a child. The only area of debate is whether one singles out citizenship as a particular factor when there are many others that are often going to be, well, just as important, if not more important, as I've said, such as the time that a person has spent in this country.
Well, I would have thought that on any view, it's relatively high in the hierarchy. The importance to be attached to it is more important, I would have thought, than many other factors one might think of. And that's without saying it's a paramount factor or a predominant factor.
Well, my lord, again, it's very much a question of looking at what Article 8 is there to protect. I absolutely accept that when you look at whether it's reasonable for someone to go abroad and to enjoy family life there, which is part of it, of course you look at a person's interest in remaining in the countries whose citizenship they enjoy. Of course, but if you look at it from the perspective, nevertheless, of where can family life be enjoyed, and you don't look at it from the perspective of this is a status, and what rights does this status give me, which is not actually what we're concerned with, then, in our submission, it's apparent that it is certainly a factor, but not one to be inevitably put at a higher level than others. And that is certainly how Strasbourg, in our submission, has approached this. It's clearly noted that the nationality of the parties is relevant, but the Strasbourg court has not sought to put it on a different level. In fact, there are, we will see, a couple of commission decisions, admittedly of some antiquity, which are in the little additional bundle that the court was handed this morning, which make it very clear that citizenship is one factor, but certainly no more than that, under Article 8.
Isn't it and we'll talk about Article 8, but Article 8 embraces the right to respect for private as well as family life. And even if you can argue that it may not affect family life, doesn't it certainly affect the child's private life if the child is raised in a country other than the country of citizenship?
Well, again, my lord, it might come into it, but one would look at a child's ability to, well, one would look at his or her pre-existing relationships, and one would look at his or her ability to develop relationships elsewhere. So again, I would say with respect, it's not inevitably a sort of higher level factor.
Maybe these children are, not in our case, but in some other case, are foreign. They may be foreign nationals, but I'm not sure that it's ever said, well, that actually is a factor which militates in favour of their being sent away to enjoy all the rights of in Tanzania, of their citizenship there.
No, I think that's absolutely right, my lord.
Well,
Yes.
but perhaps one should.
Well,
But on the other hand, perhaps one should. But on the other hand, of course, what does tend to be looked at is ties with the receiving country. Admittedly, it doesn't tend to be put in terms of nationality, but ties with the receiving country.
If they had established, I mean, if they were 3 months old
Yeah.
then one might think it was in their interests to go back to the country of which they were citizens. As you point out, if they had had 12 years living here, then the dominant or factor in the best interest would no doubt be not their nationality, but their residence.
Yes, and that's really, if I may say so, encapsulates all that we're trying to say, which is it depends.
Yeah.
It depends.
But
Sometimes one factor will be more important than another.
But I think what we're putting to you,
Yes.
we may not be putting the same thing, is that it's one thing to say length of time here is important when you're looking at a foreign child.
Yeah.
It's another thing to say that length of time here is as important when you're looking at a national child, because the national child has by definition got the close connection with this country, which a foreign child doesn't have.
Well, my lady, that we would say with respect then comes close really to looking at the whole issue in terms of the consequences that flow from status of citizenship. Whereas if you look at actual ties, which is what Strasbourg tends to be concerned with, they may or may not be particularly significant. Yes, of course, there's a legal tie. Say that you have a very small child born here as a British citizen. Legal ties, of course, entitlement to certain things, absolutely. But actual ties, not necessarily beyond the legal at that stage.
Strasbourg's quite good on respecting legal ties of a family nature as well. If one's going back to paragraph 12 of EB Kosovo, where Lord Bingham is asking whether the other person, the spouse, can reasonably be expected to follow them. In other words, the person who can't be removed can reasonably be expected to go. The reason that one's asking that question is that that person cannot be removed.
Yes.
Well,
That's why he's asking it.
Yes.
And the spouse who can't be removed, or the child who can't be removed, can they reasonably be expected nonetheless to follow? Now, that seems to me to be a fair question to ask.
can they reasonably be expected to follow?
Yes, that's a fair question to ask, and you might very well reach the conclusion in a lot of cases where it's a child that the combination of factors that are in their best interests and their nationality meant that they couldn't reasonably be expected to go.
Yeah, you may indeed.
Because they'd be giving up such a lot.
You may indeed reach that conclusion. I accept that that may well be a conclusion on the particular facts of a case, yes.
Well, in view of the time, Ms. Cars-Frisk, we're obviously not going to complete this discussion today. There's no hurry because we are searching for assistance, as I said earlier. But we'll rise now and see you again at 10:30 tomorrow morning.